What do you mean when you talk about a group company being able to enforce my employment related settlement agreement against me? I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. First off, the group company needs to be referred to, perhaps in a very general way, in that settlement agreement to be able to enforce it against you. So there needs to be quite a specific clause saying that group companies have the ability to enforce a settlement agreement against you if, for example, something goes wrong. On top of that, we're talking about what a group company is. A group company could be your employer, any companies owned by your employer. These are usually called subsidiaries. Any companies that own your employer. These are usually called holding companies. Any other companies that the owner of your employer also owns. And it could also include more complex provisions. Let's say, for example, that there is a process where the shares, for whatever reason, in a particular company are being held by a bank before being bought by another company within the same chain as your employer. There could be wording in the settlement agreement to say that regardless of that happening, regardless of the bank holding the shares in the meantime as some kind of collateral, that company with the shares that are involved in that transaction is still a group company of your employer. I hope that's answered the question, but in the meantime, if you're finding a settlement agreement hard, bring it to Richard.